Dimitrios, I propose that you take the floor with the interplay between arbitration and the judiciary. I think you have one specific case in mind.
Yeah. Sure, thank you. So I will briefly discuss a now well-established case law of the Supreme Administrative Court of Greece invalidating arbitration clauses contained in concession agreements on the basis of the ACMEA and PL Holding case law of the European Court of Justice. Now, the Supreme Court offers no reasons in support of this ruling. The only reason articulated by the Supreme Court is that the following, that concession agreements constitute investment contracts. And then, on this basis alone, the Supreme Court takes for granted that ACMEA applies to concession agreements. And in the decisions in question, the Supreme Court reproduces verbatim the reasoning of the European Court of Justice in ACMEA. Now, the first decision was rendered in 2022. Then this case law was reaffirmed again in 2023 in a dispute involving a different concession agreement. And then once again, albeit indirectly, it was reaffirmed in 2024. The last decision, I think it's characteristic of the problem because it involved a dispute. The dispute involved an investment award rendered under the dispute resolution clause of a BIT existing between Greece and Lebanon. And the Supreme Administrative Court, instead of applying directly ACMEA to the facts of this case, they made reference to their decision on the invalidity of arbitration clauses contained in concession agreements. And in this case, they should have applied ACMEA directly. So the Supreme, we have a major premise now that in theory can be applied to any concession contract. And this was not, the last one was not a tax dispute. So there is much to say against this case law of the Supreme Administrative Court. To begin with, ACMEA was a decision rendered on the basis of very specific policy considerations. There is an obvious, a given tension between bilateral investment treaties and European primary EU law. This is a given. And in this context, the European Court perceived the dispute resolution clauses contained in BITs as a device, a mechanism to whitewash the violations of primary EU law through arbitration that involved also a waiver of recourse against the award. These policy considerations do not apply to contract-based arbitration. And it is for this exact reason that the ACMEA Court clearly differentiated, distinguished between investment arbitration and contract-based arbitration, namely arbitration that originates in the free will of the parties. Now, I know that some commentators think that this argument is weak, that in order to differentiate between the two, and I get it, but it is one thing to say that the argument made by the European Court of Justice is a weak argument, and another thing to say that the distinction does not exist. The distinction exists. So Greek state courts cannot say that they abide by ACMEA case law, and that they are obliged to apply this case law to arbitration agreements contained in concession agreements. And my view, and the view of other commentators as well, is that there is some merit in the argument offered by the European Court of Justice. If someone reads behind the lines, I believe that one can differentiate between contract-based arbitration and investment arbitration on 3 points, at least. First, against contract-based arbitration, there is no, by definition at least, a negative presumption as regards the motives of the contracting parties. And as I told you before, this is not the same in investment arbitration, at least in the context decided by the European Court of Justice. And I also see in this ruling, in this distinction, an implied de minimis rule. The cumulative effect of awards rendered in investment arbitrations based on dispute resolution clauses existing in BIT, it's not the same as in contract-based arbitration. The contract-based arbitration cannot inflict, to put it otherwise, the same harm to the effective application of EU law. And I think this is what the European Court of Justice had in mind. And of course, also, it's the contracting parties. In a BIT, member states, in the eyes of the European Court of Justice, tried to evade the obligations they had undertaken under primary EU law. You cannot say, at least by definition, the same as regards contract-based arbitration. Now, PL Holdings, also invoked by the Supreme Court, is somewhat more relevant because what happened in PL Holdings is that the party invoking the arbitration clause under a BIT tried to advance arguments in favor of its validity on the basis of lex arbitri. So it may be invalid in the BIT, but since the state failed to raise an objection, it became valid. Or that in the BIT you have an open proposal to enter into an arbitration agreement, and when you file a request for arbitration, then you accept this proposal, therefore you have a new arbitration agreement. These arguments were ingenious, of course, but they would never fly. So they were condemned to begin with. But PL Holdings is specific to its facts. What the European Court of Justice ruled is that they said, forget it, you cannot whitewash an invalid arbitration clause existing in a BIT by applying lex arbitri. But in this specific case, there was no BIT. It was just a concession agreement. So it has nothing to do, I believe, with the case law of the European Court of Justice. But in fairness, I think that we also need to think what went wrong with concession contracts in Greece that made them, in the eyes of the Supreme Administrative Court, to resemble, they are not the same for sure, to resemble something like the concept of BIT. I would say two things. First, is that all concession agreements in Greece are ratified by law for no apparent legal reason. I mean, historically, this was done because it was perceived that it would protect the minister from criminal liability if you pass the law through the parliament and so on. But, and in fact, the case law of the Supreme Administrative Court was that regardless of the fact that the concession agreement was ratified by law, it preserves its contractual nature. It does not become law. Whereas the case law of Arios Pagos, of the Supreme Civil Court, was that by virtue of the ratification, the contractual arrangement become law. So, do we really need to ratify concession agreements by law? Is there no? I mean, we could find a different solution. Second, and this is the most important, the parties did that on purpose because all these are domestic arbitrations, because it's usually the Greek state and an SPV incorporated in Greece for this purpose. In domestic arbitrations in Greece, they are controlled by the provisions of the Greek Code of Civil Procedure, and these provisions prohibit an ex-ante waiver of the right of recourse against the award. So what they did, and they did it on purpose, is to have the arbitration clause contained in a concession agreement ratified by law. The arbitration clause would include also a waiver of recourse against the award, and this specific law would apply instead of the general provisions of the Code of Civil Procedure. And I think that the Supreme Administrative Court somehow saw in these cases an attempt to evade mandatory provisions of the Greek Code of Civil Procedure and to avoid state court scrutiny. Now, something about the implications of these rulings. What is important to keep in mind is that the Supreme Administrative Court ruled that an arbitral award that may be rendered on the basis of an arbitration clause contained in a concession agreement is ipso jure deprived of any legal effect. You don't need to challenge the award, and arbitral awards, even in tax disputes, are challenged before Greek civil state courts, because awards are private acts. But you don't need to do that, right? It's immediately and retroactively, when they render this decision, deprived of any legal effect. And especially in domestic arbitration, if someone understands this as a question of arbitrability, again in domestic arbitration, an award rendered on a matter that it is not arbitrable is deemed non-existent. So you don't need to file a set-aside petition against the award. It's non-existent by default. And you can raise this by way of an objection. And if you want, you have a special remedy called a petition for the declaration of the non-existence of the award. And there is no deadline to do that. You can argue 20 years later that this award is non-existent. So, and I'm saying this because it's pretty close to the concept of arbitrability. But apart from that, apart from the grounds that could be invoked to attack an award, according to the Supreme Administrative Court, they are deprived, the awards are deprived of any legal effect whatsoever. And I think this is very important, because at least in theory, any arbitral award that has been rendered on the basis of an arbitration clause in a concession agreement, in theory, if we follow the major premise of the Supreme Administrative Court, is non-existent. And they could file, the Greek state could have claims for unjust enrichment and everything. Now, what will happen then? I mean, the arbitration community, what do we hope for? Is for the Greek state to challenge the award before the Greek civil state courts, before the Court of Appeals. We anticipate that the civil courts will never agree to the case law of the administrative courts. And when you have a conflicting decision, it will go all the way up to the Supreme Court. This decision, this conflict is resolved after that by the highest Supreme Court, which we believe that it will not follow the erroneous decision of the Supreme Administrative Court. And to my understanding, I don't know, I think Nikos Moussas is here, there is a legislative committee on the modernization of arbitration law, I understand domestic arbitration law in Greece, and they are thinking of an ingenious solution, namely to attack the core of the ACMEA case law, which is that arbitral tribunals are not considered state courts, therefore they can pose no prejudicial questions to the European Court of Justice. And they are thinking, but Nikos could tell us about that, of providing that a state court may come to the aid of arbitration and the state court would pose the question instead, in order to try to avoid the principal legal argument of ACMEA. We will see how it goes, but it's getting worse. At the beginning, we said that this was an isolated event, only a tax dispute. Then they decided the same way again. And then, like 1 year ago, instead of applying ACMEA to investment arbitration, they are applying their own case law to investment arbitration, which was created on the basis of the concession agreement. So this may potentially pose an existential threat to arbitration in Greece.
Dimitrios, in the other cases, they related to what? This was tax, but what about
the first and the second were tax disputes.
Okay.
Tax disputes.
Okay. Any examples other than tax?
The third.
Okay.
The third, I don't believe and it was rendered by a different division, not the tax division, a different division of the Supreme Administrative Court. It was on the binding effect of an investment award,
Okay.
rendered on the basis of a
Because
BIT.
tax is particular.